There's something called card check recognition, which is something that the PRO Act would implement by law, but the general counsel's memo kind of suggests that she might try to go there even without a change in the law. Normally, an employer has the right to say, we're not going to recognize the union unless we have an election by the National Labor Relations Board where the employees vote to be represented by the union. But unions can get cards signed by majority of employees, take them to their employer and say, here, based on these cards, we want you to recognize us as the union representing your employees. And in some cases, it would be okay if employers did that, or at least it wouldn't be illegal. But now the general counsel has suggested that she would review what happens if the union brings a majority of the employees' card to the employer and they can't provide a good faith reason for doubting that the union has majority support. So hypothetically, if you had 10 employees and the union brings you 9 cards and you have to acknowledge that they're all signed by the 9 people that work for you, that clearly should be in a bargaining unit if there were a bargaining unit. It seems like the general counsel might be saying at that point, if you refuse to recognize the union, you have to have some good faith reason to dispute the employee's support. Where historically you've had an absolute right. I mean, barring you engaging in some really shady behavior, to just say we want an election. So we'll have to see where that goes.